All right, this courtroom opens with the judge calmly laying out the ground rules, but beneath the formal tone, tension is already building. The defendant has chosen to represent himself, and the judge carefully explains that standby counsel is only there for procedural guidance, not strategy. It's a subtle but important distinction that hints at potential conflict. You can sense the court trying to maintain order while anticipating complications ahead, setting the stage for a hearing that may quickly veer off script.
Good afternoon, everyone.
Good afternoon, Your Honor.
Your Honor.
Yes, sir. Good afternoon. All right, Mr. Watts there at the jail. Can you hear me okay?
Yeah.
All right, let's go ahead and go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus James Brent Watts. Case number 22 CR 83. The state appears by Cheryl Pierce. Defendant James Brent Watts appears in person pro se. Attorney James R. Watts appears as standby counsel. We're set today to take up a motion filed by defendant Watts, as well as an issue raised by attorney Watts as to what his role is as standby counsel. I thought it'd be appropriate to take that up on the record with defendant Watts present, so everybody's on the same page as to what attorney Watts's role is as standby counsel. And I think I'll address that first. In my vision of standby counsel, attorney Watts would be not to provide legal advice or trial strategy, that sort of thing, but rather be there to explain trial procedure, how things work, the inner workings of a trial, from voir dire, opening statements, jury instructions, opening arguments, closing arguments, that sort of thing, procedural matters, ensuring that defendant Watts has a fair trial, that the trials run efficiently. I don't expect that you'll participate in any examination of witnesses or address the jury in any manner. I just want it clear that you're helping with the legal type things that go on in a trial rather than strategy, because defendant Watts has chosen to represent himself and wants to present his theory of defense himself. So that's in a nutshell kind of what I expect your role to be. Also, you might be able to provide him with some limited access to the outside world for maybe providing some phone numbers or addresses for witnesses he might want to get in touch with. I don't expect you to be a role of private investigator or anything like that, but as defendant Watts is in custody, if you can help him with just maybe providing some information you can get there handily, I think that would be appropriate. Also to advise him of certain rights he might have, such as his right to testify or his right to choose not to testify, those sorts of things.
Now the standby attorney steps in with a measured but revealing concern. He explains how unclear boundaries can create professional risk, even disciplinary trouble, if he's suddenly forced to take over mid-trial. His cautious tone suggests he's already uneasy about how unpredictable this situation might become. The exchange feels polite, yet loaded with tension, as the court reassures him while the possibility of chaos quietly lingers in the background.
So, Attorney Watts, does that kind of help clarify what your role will be?
Well, it does, Your Honor. And the reason I ask is, it was not very clear, and that's not necessarily the fault of the court by any means. There's very little guidance out there in the case law as to exactly what that representation means. It has always struck me that if you're not very careful, it can be a trap for an attorney to bring on 1507 or some sort of a disciplinary problem, that you're setting yourself up for that sort of problem. I don't want to be in that position. I've told Mr. Watts, James B. Watts, that I can assist in obtaining subpoenas and documents if he helps. We haven't really discussed strategy very much, to be perfectly honest. He's not really interested in hearing what I have to say in terms of strategy. So I think that helps a lot, Your Honor, as to, I've noticed some cases that have come up through the appellate system where a standby or counsel has been essentially put into the position of taking over when a defendant in the middle of a trial turns to him and says, I've done all I can, would you take over here? And I don't think that's a realistic position to be in for any attorney, to have to step in mid-trial and take over a trial. And I'm hoping very much that's not the position I'd be expected to be in should that happen.
Well, I've seen some of those cases as well, and frankly, I don't feel that that's appropriate for someone who's assisting the standby counsel. So those are what I had envisioned as your role. Let me address Defendant Watts. Do you have any questions as to the role of Attorney Watts as standby counsel?
This is where the calm courtroom atmosphere takes a dramatic turn. The defendant launches into a fiery rant, attacking attorneys in sweeping, extreme terms and framing his views in moral and religious language. The judge attempts to steer the discussion back on track, but the momentum has already shifted. What started as a procedural clarification now becomes a revealing glimpse into the defendant's mindset, instantly raising the stakes and signaling that this hearing may become increasingly unpredictable.
I've asked him for things and he hasn't gotten them, but I've had bad experiences with attorneys. Attorneys in the Bible are the worst people you can possibly. They're absolutely of Satan and the devil and everything else. Attorneys and lawyers are the worst people there are. They're evil. I've been screwed by them up at Chase County. They've allowed people to lie, and I had to do time in prison. So I'm not going to deal with that. They're going to be put to where they need to go. Hell. I don't know of any attorneys that I can say have done good. So no,
Mr. Watts, you're entitled to represent yourself, and that's what
parents have committed perjury, saying because they're afraid that they're going to get in trouble for something, for me having firearms. I hid them in their house. I've always had firearms. I always will. By the laws of the heavens, laws of the universe, there's no restrictions on anybody having firearms to fight evil with. So I'm not going to deal with that. I'm not going to abide by that law. That law is purely satanic. But anyway,
Mr. Watts, we're kind of veering away from the issue of Mr. Attorney Watts' role as standby counsel. So, Ms. Pierce, do you have any comment regarding the issue of Attorney Watts' role as standby counsel?
No, I think that the court and Mr. Watts have a handle on it.
All right. The other issue I wanted to address today is a motion filed by Defendant Watts, which is titled Motion to End the No Contact Order Between Me and My Parents. So, Defendant Watts, I'll allow you to argue your motion.
The discussion escalates as the defendant pivots to firearms, personal rights, and claims about authority. His arguments grow broader and more philosophical, drifting far from the original motion. The judge repeatedly tries to redirect him, highlighting the widening gap between the court's focus and the defendant's narrative. The tension here isn't loud, but it's palpable as the court struggles to keep the hearing grounded while the defendant continues to expand his arguments.
At this time?
Well, my parents are guardians and they're also trustees of an estate. They handle my money and I need access to my money. I can't get my money and I need that polygraph. I want it for evidence. I can introduce it in court many different ways, whether it's taken. The law enforcement use polygraphs for, to establish probable cause, or to disallow, probable cause, or not allow, or not have probable cause, the showing of it. They can absolutely be, I can file them in with filings if nothing else. I want that polygraph taken. But anyway, I've got many filings. We're going to have to, I've got evidence. I've got to talk to arms list on my accounts there. And I've got to also call the phone companies, contact them to see what records they have and what arms list has. I've got to get responses from them. The whole idea of a preliminary hearing is to tie down evidence in that, because there are absolute perjury attaches in a preliminary hearing. There don't need to be any lies or perjury like that from my parents going on the firearms not being mine or me shoving them down. I'm not going to deal with it. Now you've got a situation because the deputies told my parents that they were going to get in trouble if I had firearms, evidently. I'll have to find out exactly what all was said. They haven't wanted to tell me, or even county attorneys talking to them about me having firearms. I believe every felon needs to have firearms. The felons aren't the evil and wicked people. It's all positions of power and authority in society and governments and the wealthy that are the real evil and wicked people. The ones that are in the prisons and jails are some that have been possessed by some devils, demons, and unclean spirits at the commands of the real evil and wicked ones to try to fool everybody. The evil people are in jails and prisons. They are.
Mr. Watts, you're kind of veering away from the motion that you filed was to allow contact between you and your parents. Do you have any more?
Yes, I do. I've got bank records I've got to get, show my access to cash on hand. I've got phones out there I've got to get a hold of. I got a phone at the Butler County Jail I've got to get a hold of that they seized down at Leon. I need chargers to go with them, but I'm going to have to go through them and pull out different messages that I haven't deleted yet on me purchasing firearms and ammunition.
And that's information you believe your parents will be able to provide you?
They have the access to the phones down there. Also, the county attorney, I've requested paperwork listing all of the firearms and ammunition that was seized. I need to know that because I'm going to question every bit of that at the preliminary hearing. I need full list of everything that was seized of my property. And it is my property.
All right, Ms. Pierce, your response to the request for Mr. Watts to have the no contact order lifted with his parents?
Judge, quite honestly, I thought that had been lifted months ago. There was a time that he was in the hospital that we actually did a order lifting that. That was a few months ago. Also, my contact with the county jail around that time, as I recall, was that no contact order was lifted. If the jail is still operating under a assumption that it is still in place and they need some kind of written order to the same that it is not, I will be more than happy to do that. I have no problem with him having any contact with his parents. Again, I would request that all of their statements are recorded, so I don't have an issue with that. So, again, I thought that it was been lifted. That issue had been addressed a long time ago.
Okay. Do you recall when that may have occurred?
Well, when he went to the hospital required a order, and that was way back.
Well, Ms. Pierce, if you're not objecting to it, then I don't think it matters at this point.
I guess.
Guys, The hearing moves toward resolution as the court addresses contact with the defendant's parents. The judge attempts to clarify communication issues and ultimately agrees to lift the no-contact order, aiming to remove one obstacle. Even then, the defendant continues raising concerns about access and evidence, showing how persistent the friction remains. The judge pushes the case forward, emphasizing the timeline and the need to proceed. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
My question is to the jail, and maybe I don't know if the person that's there with Mr. Watts can answer that question or not, whether or not they are still operating under the thought that there was a no contact order. But again, I don't know why they would be, because I've spoken to Mr. Reynolds about it, so I don't know if that's I don't know if Mr. Watts has attempted to make some kind of contact with his parents and he's being told he can't. I don't know if, I don't know exactly what the circumstances are, that the reason that Mr. Watts continues to believe that there's no contact order in place.
All right, well,
I don't believe the phone's going through. I don't believe the phone allows them to answer. It needs to be checked on. But I need to make sure I have access to money for
well,
different.
the court will lift the no contact order. If the order hasn't been lifted previously, that will allow you to have contact with your parents. If you need to communicate with them by mail, if you're not able to get in touch with them by phone, you're certainly allowed to do that, Mr. Watts.
Okay. Is there any way we can have the phone checked to make sure it would connect if they will answer it?
Well, that's not something that's something the court does.
You can't order Reynolds to check the phone and make sure it'll connect.
No.
I've got to talk to them about access to those other phones out there, cell phones. And then the jail's got one, but I need to have access to them and chargers so I can go through the text messages and possible phone numbers on those too.
Okay. Well, there's the no contact order is lifted, so you can communicate with your parents. So, Ms. Pierce, would you be able to produce just a brief order? So we've got some. I didn't see anything that was part of the court file, just so that's part of the court record.
I will do so, Judge.
Okay, now we've already got the preliminary hearing. We've already set that. That's going to be October the 1st at 9 o'clock. That's an in-person hearing here at the
There's no way Your Honor, there's no way I'll have my evidence by that time.
Okay, well, we've got it set, so if you're going to be seeking a continuance, you can raise that at the appropriate time. But for now, this case has been pending for a long time. We need to get it moving. We've had this date, the preliminary hearing date, set since August the 12th. So, all right, I believe that addresses the two issues the court wanted to take up today. Ms. Pierce, anything further?
No, Your Honor.
There's other filings that are in there. One is to reschedule the October 1st date and a motion, and then also, the list of the firearms and ammunition that I'll be addressing in court that they say were their property. I need those lists provided to me, and I need to have that polygraph too taken. I don't know why we haven't got situated on that.
Well, Mr. Watts, if you want to pay to have a polygraph done, you can do that. It may not even be admissible. You'd have to file a motion to.
I can still have it, use it in other court proceedings.
Well, if you want to do that, that's got to be at your own expense. The court doesn't provide funds for you to do that.
Yeah, but I don't have access to getting in touch with anybody to get that done.
Okay, well, I don't have any other motions that have been filed recently, Mr. Watts. Have you received anything, Ms. Pierce? The last one I have is the motion to end the no contact order, which was filed August 23. I haven't seen any other motions that have been filed since then.
Judge, according to what I have in my file, on September the 3rd, there was a motion that this is filed by Mr. Watts, the defendant, motion that I be given list of all my firearms and my ammunition seized from me. And then there's also another one that is, and that was done on September the 3rd at 11:47 a.m. And then there was another one that was filed September 3rd at 11:47 a.m. Motion to reschedule the October 1st date of the preliminary hearing so I can get all my evidence collected. And then, of course, the motion to end the no contact order, which was filed on August the 23rd. I think those are the ones that that I have that are the most recent filings, Judge.
All right. Angela, can you try to pull those up, please?
I can't agree.
All right. I'm going to take a brief recess and I'm going to look these over. I'd rather just take them up now.
Judge, I
Can you address
just,
those?
yeah. Judge, I want to clarify with the court that Mr. Reynolds, who's watching this, indicated that the no contact order was lifted, that Mr. Watts and his parents have been speaking periodically on the phone. Mr. Reynolds checked the phones and the phone is not blocked, was unblocked months ago. So Mr. J.B. Watts, defendant, has had access